Divorce can be one of the most stressful events in your life. It can be overwhelming to figure out how to get from the decision to get divorced through to the process of actually being divorced. One of the reasons it can be daunting is because there are so many ways to get divorced. One of the most common and least contentious ways to get divorced is an uncontested divorce, which is a divorce that takes place outside of court when both parties reach an acceptable agreement. The first step is to find an attorney that you feel comfortable working with. Once you've found an attorney that you're comfortable working with, it's a good idea to let your spouse know of your intention to seek a divorce and advise them to hire an attorney as well. The next step is for you and your attorney to decide how to move forward. You and your attorney will decide whether or not to file a summons, which is a legal document submitted to the courts that begins the divorce action. The decision of when to file your summons will be made with your attorney because the date that you file will be the date of commencement and will have an effect on maintenance, otherwise known as alimony, and marital assets. While a summons is a legal document that is filed with the court, it does not indicate that your divorce will be litigated. The next stage of an uncontested divorce is information gathering. At this point, you would fill out a document called a statement of net worth, which gives an outline of your assets and a monthly overview of your expenses, liabilities, and basic financial information. You will also exchange financial documents with your spouse, including pay stubs, tax returns, bank statements, and other documentation relating to real estate or businesses. While the exchange of documents is typical in a divorce case, some parties choose to do less discovery where there was transparency during the marriage. It would be at this point that the parties would value any assets, typically real estate, a business, valuable personal property, and take depositions if necessary. When you're comfortable that you have all the necessary information from your spouse in order to make an informed decision about settlement, the attorneys can start negotiating. There is no one way for negotiations to take place. There's usually some combination of letters, phone calls, even meetings between the attorneys, you, and your spouse. Negotiation will involve all aspects of your divorce, not just financial. That includes custody of children, time sharing, child support, maintenance, as well as the distribution of assets. Once an agreement is reached, a written settlement agreement is drafted by the attorneys, signed by the parties, and filed with the court along with your other uncontested documents. The process as described here never requires you to go into a courtroom or be seen by a judge. All negotiations take place between you, your spouse, and the attorneys. This is typical of the uncontested divorce process.